Hi, everyone. Thanks for joining us here. I'm really excited to get to talk with Malita, Taylor, and Chase about our incredible win. So a couple of things before we get started. First, we have ASL interpretation. Jenny is the interpreter, so if you need that, you can pin her video. We also have closed captioning. You can press CC at the bottom if you need captioning. And then I think we'll all introduce ourselves and get started. So I'm Gabriel. I use he, him pronouns. Like all of us, I'm a lawyer in the LGBT and HIV Project at the ACLU, and I'm one of the lawyers who worked on Aimee Stephens' case. Malita?
Hi, everyone. Good morning. I'm Malita Picasso. I'm a legal fellow here with the LGBT and HIV Project at the National ACLU. And my pronouns are she, her.
Chase?
Hi, everyone. I'm Chase Strangio. I use he, him, or they, them pronouns, and I am currently in New York City. And I work at the LGBT and HIV Project at the ACLU, and was one of the lawyers on Aimee Stephens' case.
Hi, everyone. My name is Taylor Brown. I'm an attorney on the project as well. I use she, her pronouns, and I'm at ACLU National here in New York City.
Great. Back when I first imagined us talking to each other about this decision, I both did not imagine that we would all be in our separate homes, and I did not imagine that we would be celebrating such an incredible victory. I mean, I thought that we might win, but I didn't think that even a win would be as complete a win as this was. So I'm really happy to get to talk with you all about it. What are your reactions to the decision?
I mean, I'll start by just saying, I don't think I've ever been more happy to admit that I was wrong in my prediction on the outcome of this case. It was very surprising. I was also in California at the time, so it was very early. I had just woken up, and to get to wake up to just countless emails saying that we won and that it was a full win was just really, I couldn't ask for a better way to start, the week, the day in this difficult time that the country is going through right now. And so it was a light that I really needed.
Yeah, and I'll say for everyone who's watching, so in the project, we have a huddle on the decision days. And I had never joined the huddles before because, who wants to wake up that early? And this was my first one. And so it's like it's all of the different stakeholders from the ACLU and the LGBT project on the call. And we're waiting for the decisions to come out. And it just so happened on the first one that I joined, that was decision day, and it was huge. It was just amazing to see everyone smiling. Everyone was freaking out, so happy. The pages weren't loading, like we're pasting it in the chat, we're screaming, like trying to figure out, and it was an amazing experience.
Yeah, no, I am so surprised. I definitely am not an optimistic person. But that day I had, there had been an incredible rally in Brooklyn with over 15,000 people coming together to rally for Black trans lives. And after that, I was like, whatever, it doesn't matter if we win or lose. Like, we're already on the trajectory in the right direction. We can resist. And so I was less nervous than I had been in some ways other weeks, but still really nervous. And I was also, I was at my mom's house, which was random, and my kid was doing school, and it was a complete chaos. But it was just like every, page loading one at a time. I was like, wait, where's the horrible part? And I think Gabriel and I and Malita, like 6 months ago, were discussing this. We imagined it would look a lot like us, like reading like really offensive and we could do that with Alito's dissent, but reading like really offensive passages from the majority opinion and just like grappling with it, but it's a really different circumstance. So I feel I'm still not, I don't think it's sunk in totally.
I know, me neither. And I definitely, Taylor, you're right. When we were all sitting on that Supreme Court huddle and we couldn't read the decision, and I was like screaming, "Everyone be quiet, Chase can read it. Chase, just read it out loud for us." It was like so chaotic, and also so amazing. And yeah, you know, I think going in, like, even though like I'm one of the people who was somewhat more optimistic about our chances of winning, I was going in just like, you know, with all of the like terrible attacks in our community, like all of the things that Trump did on the Friday before, like in terms of healthcare, in terms of housing, in terms of immigration, and then just in our lives, in our communities, like the ongoing killings of Black trans people, I was like, I went in angry. And I was like, all right, if we lose, I'm already angry. And we are ready like to rise up. And it's not like a great decision has solved all of those problems, right? I mean, I do think that it's kind of solved the Trump's healthcare rule as it applies specifically to anti-LGBT discrimination. But we've got a lot of problems still to solve and a long way to go. But still, to have something to celebrate in this moment felt amazing. Oh, I also forgot, I was supposed to tell people in the audience, if you want to send us questions, you can just use the Q&A function, and we'll get to them as we discuss.
I also think now that I know, Taylor, that this was your first one, I am a very superstitious person. So if this ever should occur again, I'm gonna make you come to every huddle. As I don't
totally,
forget these things.
I didn't want to take credit for this win, but I'll take it now.
I mean, we made Louise Melling, the deputy legal director, wear the same outfit every day. That was a rainbow dress that she decided was good luck, and so then it felt scary to not let that be part of the process.
Does anybody have a favorite part of the decision they want to talk about?
I mean, this is very superficial, but I will say that, you know, one of the things that, you know, we did in the briefing was like very strategically focus on the sort of very straightforward but for sex analysis, which creates this, you know, per se rule that has less ambiguity than other things. It's sort of, you know, the first and last paragraphs of the decision are just so clear. It's like, it is illegal to fire someone or otherwise discriminate because they're LGBTQ or homosexual, as it is known in the Supreme Court. So that part's not my favorite. So the clarity of it was I was, you know, and then I'm also used to Justice Kennedy's opinions where there's like all this flowery language, and you're like, what does this mean? And so there was that clarity. And then on the sort of more superficial side, as I'm someone from Boston, I liked the sort of firing someone because they're a Yankees fan reference. I appreciated that.
One of the things that I really liked about the opinion is actually a passage from the section where the majority is sort of rebutting each of the defendants' arguments. And I think it's like on page like 27 or 28, it says, to refuse enforcement just because the parties before us happened to be unpopular at the time of the law's passage would not only require us to abandon our role as interpreters of statutes, it would tilt the scales of justice in favor of the strong or popular and neglect the promise that all persons are entitled to the benefit of the law's terms. And I just felt that that was so spot on. And, you know, I've heard commentators say, you know, it's symbolic and not really anything practical, and that may be the case, but I do think it is a really important signal that, you know, animosity directed at a particular group should not be taken into consideration when applying the law, at least not to prevent the subject of that animosity from being protected.
Yeah, that was also, like, that's my favorite passage as well. I got a little bit teary when I read it. And I know that the promise of equality under the law in many ways is an illusion, as we all know, but to have that affirmed so clearly, it means so much to me, at least. And I think also, I remember back, I was talking to folks at the ACLU about this case, and I was laying out our argument for how trans people and LGBTQ people are obviously covered, and how clear it is under the law, how clear it is in the facts, how clear it is as a matter of logic, how clear it is as a matter of, the court's own statements about how it interprets the law. And people asked, is there anything that you're worried about here? And I said, yeah, I'm worried that anti-trans and anti-LGBTQ bias is going to lead us to a terrible decision. We've seen that happen before. And that's a lot of what the other side's argument was. They were saying, look, everybody agreed that LGBT people were terrible back in the 60s. So obviously this law can't mean this. Obviously everyone knows that trans people being allowed to be a part of the workforce or to be allowed to be a part of public life in any way would be terrible. So the law can't mean this. Then the court is like, no, the law means what it means, and we're not going to say that it doesn't mean what it means just because you don't like the people it's protecting in this situation.
Yeah, I'll say my first favorite are the most important 14 words that I think that we're all going to be citing to, and very in the very near future for many cases, is an employer who fires an individual merely for being gay or transgender violates Title VII. Like, those are probably some of the most important words of 2020. Personally, I just thought it was great. It was just way more than I expected. So I think, like Chase, I'm still trying to digest so much of it, and just thinking like, do we start a Gorsuch fan club or no? Is it too early? I don't know. But I used to see an argument, pre this decision in many Title VII cases where defendants would say, well, we discriminate against transgender men and transgender women. We're not discriminating. And there's a part where they say, you've actually doubly implicated yourself for discrimination. And to see that so clearly, that argument used to always just get under my skin so bad. And then, not my favorite part, but I told everyone on the call that I always jump to the dissents first, pretty much after I've read the whole thing, just to see what they're saying. And, I think the dissenting opinions are often cited sometimes, we'll see, and used as the people in the world who are anti-trans and are anti-LGBTQ are planning their next attacks on our community. I think we can look to the dissents for arguments that they're going to raise and things that they're going to want to say to try to pass laws and to try to pass regulations and rules. And I was just they were very interesting.
I will say that Justice Alito, in his rage, much like Justice Scalia, couldn't help but map out all of the positive consequences for us of the decision. The sort of, in criticizing the majority opinion, one of the things that Justice Alito does, which Justice Scalia often did as well in his dissents, is sort of say, well, all of these things are now going to happen. Like, LGBTQ people will now be protected in all of these contexts. And so we can also use the dissent in our favor as we're sort of advancing the arguments in the service of the broadest interpretation of this really clear and quite excellent decision. And one thing, I know we're going to answer questions in a second, but one thing I wanted to add to what Malita and Gabriel flagged about that passage is it was really interesting because I suspect it wasn't written by Gorsuch. I suspect it was added by someone else, perhaps, in the way these things go. But it is sort of, in some ways, a direct rebuke of Gorsuch himself in the argument, where he was sort of suggesting both, well, there's no way that this group of people could have been covered at that time, and also, wouldn't it create massive social upheaval if we included you know, I think he was referring specifically to trans people, but maybe LGBTQ people more broadly. And this passage is just such a different sort of way of contending with the textual application and sort of thinking out about it in a different way. So it's interesting to see in the 8 months since the argument sort of how some of the things evolved. And you never really know in argument what people's questions are actually about. But it was nice to see that, because that was one of my concerns at the argument, was that Gorsuch may just not be willing to go there, even if it was aligned with his judicial philosophy.
One of the many things that makes me angry is the way that everybody thinks that everything is going to be, you know, upheaved in some bad way just because we are existing. So yes, let's talk about some of the questions, which actually I think what you were just talking about with Alita's dissent is a really nice lead-in. So the first question that we have from Alina is, what do you think the implications are for Title IX, especially with the Department of Education trying to deny federal funding to Connecticut schools because they aren't discriminating against Black trans girl athletes? Chase, I don't know if you want to start us off with that one and tell us a little bit about the case that Alina's talking about.
Yeah, so thanks for the question. And I think, you know, in general, I feel really optimistic about sort of the way that this decision is written and all of the positive things it will mean for interpretations of other federal statutes that prohibit discrimination because of or on the basis of sex. The Title IX question in particular is about, that you ask is about, for those who don't know, this case in Connecticut that involved cisgender students who have sued various governmental entities in Connecticut because Connecticut has an inclusive policy that is consistent with state law and federal law, I would argue, that allows transgender athletes to participate in athletics consistent with gender identity without any proof of hormone therapy or other medical treatment. And two young Black runners had some success in their high school career, which is, you know, notably over now because they've both graduated. But these four cis individuals sued Connecticut, arguing that the inclusion of trans women and girls in athletics violated their Title IX rights. So, and then they filed a complaint with the Office for Civil Rights with the Department of Education. So there's two proceedings going on there. And a few weeks ago, Ed issued a statement of finding that their policy violated Title IX, so that they actually held as a matter of just administrative enforcement interpretation. It's not binding law in any way that it violated Title IX, according to the Trump administration, to include trans students trans girls in athletics for girls in the context of the Connecticut facts. The case is ongoing and it's procedurally all over the place. I think that there's an incredibly strong argument that now that, you know, Title IX per se covers LGBTQ students. The posture of that other case is sort of the reverse, whether it violates Title IX to protect trans students. I don't see any way that that decision stands in light of this particular decision on Title VII. I think that the question is going to be, with respect to Title IX and the various regulatory schemes, how are lower courts going to interpret this decision? And a lot of what Gorsuch talks about is, you know, sort of the nature of the text of Title VII and its focus on the individual, which is also true in Title IX, you know, to a large extent. I think the one area where it's less clear is in the context of sports, where there is sort of more of an analysis of groups. But again, no program statement and no regulation implementing Title IX can violate the statute itself. And so I think that, you know, this gives us a lot to work with in our Title IX student athlete cases, and particularly in Connecticut. I think that, you know, if this were a responsible administration, they would rescind that findings letter as being inconsistent with their authority under Title IX. I don't expect that to happen, and I think this will continue to be litigated. But we're counsel for the two young women runners who were just personally attacked by name, both in the legal documents and in, you know, a really vicious media campaign. And the students are represented by ADF, the CIS students in Connecticut. So I'm hopeful that this will have a very positive impact. I don't think that certain litigants are gonna, you know, let this be the end of the story though, particularly not those represented by ADF.
We have a couple of other questions about the impact of this ruling in other contexts. So we have one from Drew asking us, are LGBTQ protections now guaranteed anywhere in legislation or regulations that say because of sex, or is this specific to Title VII? I don't know, Taylor or Malita, do one of you want to talk about that? Add a little bit more?
Sure. So I think that I guess before I jump into other contexts, I also just want to highlight that I think for me at least, when I think about Monday's decision, I actually think the gravity of the impact is much more in what it didn't do than what it is now doing. So, you know, for decades, the EEOC has recognized that trans people are protected by Title VII. And so loss in this case would have really been a major change. And so now we're just seeing that trans people and LGBT people are basically in the same boat as everybody else who's bringing employment discrimination claims, which is fighting an incredibly difficult uphill battle. I just also want to, you know, us to keep in mind that the vast, vast majority of employment discrimination cases don't win for the plaintiff, and that they result in oftentimes very bad laws, especially for particular types of plaintiffs. So, for example, we know that people who hold intersectional identities, like Black women, are really the least likely to prevail in employment discrimination cases. And so I do want us to think about just putting this win in that context, that really what they've done is just basically allowed trans people and LGBT people into the race that everybody is already running. So with that in mind, I think when we think about the implications in other areas, the major, I guess in my mind, the major implication is that wherever there's a protection against discrimination because of sex in federal law, it's difficult in my mind to think of some type of justification for not applying this same interpretation of sex from Title VII to those anti-discrimination laws as well, unless there's something in the statute itself that, you know, carves out particular exceptions. So I do think that there are implications for other civil rights statutes, at least at the federal level or at the state level, that look to Title VII for its in interpreting, you know, the protections against sex discrimination. But I do want us to keep in mind that this is like really just the beginning, or rather a continuation of the work, and that we have a long way to go in, you know, defining what it means to engage in discrimination, right? Because here, one of my issues with the decision was also how much it focuses on intent of the employer to discriminate, you know, very specific facts where the employer, you know, fired Aimee Stephens because she was trans. There was no question about that. most employment discrimination cases don't have such clear facts. And so it's really going to be up to, advocates to educate the courts and define and expand the definition of what it means to discriminate against somebody in employment because they are trans or because they are LGBT. So that doesn't really directly answer the question, but that's just one thing I want us to keep in mind.
I would say in an ideal world, we would hope that it would have implications for any civil rights statute that protects people on the basis of sex, because I mean, if you think about other protected classes like race, like you cannot hire, I mean, it's illegal to not hire Black people, and it's the same way in a school. It's illegal to not admit Black pupils. That's the ideal world of how civil rights work. You shouldn't be able to allow discriminate in one place versus the other place just based on, because it's school, it's work, it's it's a coffee shop, whatever. So again, ideally, but as I found as a lawyer, and I think as everyone else knows, the real world does not work on logic. And so, as Malita was saying, it very much is, the law is very fact specific oftentimes. And so we have to apply this in holdings where the adverse employment situation isn't firing, say it's a healthcare situation, or say it's something like that, or bathroom access, as they clearly delineated. We're likely going to have to bring cases that are going to have to make sure that this holding is applied in those contexts to make sure that it's not just about firing, but it's any adverse treatment of a trans or gay employee in the workplace, the same as anyone else. Like that's likely what will happen.
And I see we also have a question from Q Latinx about what the implications are for religious places of employment, like coffee shops, bookstores, private religious institutions of learning. I can take a shot at that and then people can add. So Title VII does have an exception if it's called a ministerial exception. And it means that if you're hired to do specifically religious work, like to be a minister or to provide religious instruction, then the employer is allowed to discriminate against you in some ways. But other types of employment, even if your employer is religious, you still have those protections against employment discrimination. So if you are hired as a cashier in a religious bookstore, then they should not be able to discriminate against you because you're LGBTQ. Definitely though, our opponents are working hard to try to broaden that exception and to also push for religious exceptions to other types of anti-discrimination law in a lot of different contexts. And the Supreme Court has already said that it's going to review a case in Philadelphia about whether it was okay for the city to stop contracting with a religious provider that refused to abide by an anti-discrimination law. So we'll be finding out more about that soon. I also want to point out, though, that for customers in coffee shops or customers in bookstores, right now, federal law doesn't prohibit sex discrimination in places like that, in places of public accommodation. It should. It prohibits sex discrimination in a lot of other contexts, like housing and healthcare and credit, unemployment. But that's a gap that we still need to fill. So we're still saying that we need to pass the Equality Act, partly just to make sure that gaps like that are filled, that sex discrimination is unlawful everywhere.
One of the things, the sort of historical things that I totally agree with Gabriel's analysis. And relatedly, one of the historical things that is so satisfying in a certain way is, in 1964, when the Civil Rights Act was passed, it was the sort of white supremacist segregationists that threw sex in at the last minute as a poison pill to try to kill the legislation. And not only did that not work in the end, but now it's that very language that's being used to apply a logical interpretation of the law to include discrimination against LGBTQ people. And then the other thing is that there was, some very compromised versions of ENDA, the old Employment Non-Discrimination Act, that excluded trans people and had significant religious exemptions, but that are much broader than Title VII's existing religious exemptions, and had, you know, the anti-LGBT forces at the time just compromised and passed that ENDA, we never would be able to get the decision that we got this week. And so in some ways, the forces that were trying to, you know, sort of expand white supremacist and anti-trans notions to maintain those within civil rights law, ultimately, you know, were responsible for creating the outcome that was far more expansive from the court this week. And again, that's not to say that formal equality is the expansive justice that we need, because I think, you know, there's lots of ways that people, you know, especially in the United States where most people are at-will employees, it's like Malita said, it's so difficult to prove intent. I mean, one of the remarkable things about these cases is that the employers were like, oh yeah, no, we fired these people because they're LGBTQ, and that is not usually how it goes. And then the other thing that I just want to note that we all are working on, in different ways too, is that, you know, employment, you know, protections don't get you very far when there's widespread, for example, discrimination based on prior contact with the criminal legal system or immigration status. And so there's all of these other ways that people are pushed out of the labor market that this decision won't fix.
We also have a question from Dee Glickman about are there any implications for PREA, which is the Prison Rape Elimination Act, and our ability to help incarcerated trans people? I mean, one thing that I just want to note is that a lot of people are saying that this is the first case that the Supreme Court has heard with a trans plaintiff, and that's not true. Dee Farmer brought the first case. She was an incarcerated trans woman who was raped and who brought her case to the Supreme Court and won. And we represented her, the ACLU represented her once it got higher up in court, but she actually started the case herself as a jailhouse lawyer. And still, most of the federal litigation happening on trans issues is brought by jailhouse lawyers. You know, it's incredibly important that we're constantly thinking about what we can be doing for incarcerated people. I feel like this decision struck me in a funny way because, you know, we won this case, which is like tremendous and huge. And also, you know, just last week, we got a bad decision seeking a preliminary injunction to try to get people released from a facility with a big outbreak of COVID-19. We were trying to get chronically ill people released from that facility, and the court said, no, they don't get to get released. It doesn't matter that they're at high risk of dying. So it's tricky to hold those two things together. I feel like there are so many things happening in this moment and in this year that are both like huge causes for celebration and like cause for mourning and alarm, like all of the good and all of the bad at once. I don't think that this decision is going to do a lot immediately directly for incarcerated people. I do think that we can use it in constitutional claims that trans people who are incarcerated bring to say, you know, you're treating me worse than other people who are incarcerated and you're not allowed to do that. I think that this decision could be helpful there. But this decision is certainly not going to get people out of prisons. And that's ultimately what we need if we want to keep our communities safe.
And just one other note about yesterday is the court also denied review in the qualified immunity case, or what was yesterday, the same day that this happened, whenever that was. So it is just like the counterpoint to, you know, essentially greenlighting all of the police violence while also, you know, encouraging, you know, sort of broader capitalist participation in the labor market. It does seem connected.
I'm curious about how you all are holding all the things that are happening in this moment, like this decision and Black Lives Matter movement um, and COVID-19 and all of the different things that are happening. We're still waiting for a decision in DACA. I don't know, just like how are other people managing all these things?
Yeah, so after the decision came out, I went to a rally at Stonewall here in the city, which is huge. That's where our movement is. In the history books has started. And so it was me and primarily other Black and Brown trans women speaking to a very large crowd about like what this decision means for our community, having a space for release. And that was amazing. And I think that it just reminded me that as we are in this moment as a nation where Black people are once again, taking to the streets, demanding justice, we're asking for the very same things that trans people and LGBT people are asking for today, that we have to know that the Civil Rights Act of 1964 was because of Black people, because of Black civil rights activists who were asking for job protection, who were asking for protections in schools, and all of the various civil rights acts that passed. And so I think it was just so, not coincidental that this win came at a time and in this moment where to remind us that we're all in the same struggle, that the Black Lives Matter movement is our movement, and we have to make sure that we're always supporting Black lives. We're always, centering those stories in our movement, because that's why we're here. And so it was wonderful in that aspect to just be in community amongst so many intersectional people, and to know that, yeah, we're still here. We're still going to show out in the midst of the world seeming like it's ending with a horrible president, with a horrible pandemic that's ravaging our country and the world. But I'm always naively optimistic, I find sometimes. And so it definitely renewed my fire. And we have so much work to do off of this. And I think the court handed us something that handed us another weapon in our arsenal. And I think that we're only going to come on stronger and better. Hopefully when Biden's in office, we'll get a little bit of help. But it was something much needed after 3 months of being locked in the house and everything that's going on in the world.
Yeah, I think, Taylor, you said it so beautifully. I think it's just, I felt so conflicted when we got the decision. And I think that it's hard to hold something that feels really surreal, because as I mentioned earlier, I had absolutely not 1 inch of me felt that we were going to win. And that says nothing about the strength of the case or my feelings about the strength of the case or the way that it was litigated. It was more just, after in this year of just loss after loss after loss of life and in the courts, and just feels like every segment of society, I just really couldn't even imagine that this would turn out this way, that this case would end with this result. But it's really painful, it's painful to think of how many people, how many trans women, especially, how many trans women, Black trans women, aren't here to celebrate this with us. And how Aimee Stephens just passed away just before the results, the decision came out. And so it's hard to hold that. I feel that it's, I have moments where I allow this to really inspire me and energize me and motivate me to keep going. But I think like a lot of us, it's also hard not to be able to hold space with one another in person, and not to, comfort one another and support one another. And so I think I'm still kind of struggling through how to hold all of this at the same time. But I think that looking to Black and brown trans women for guidance and for, information from them about what support looks like moving forward is really the way to go. I think that they have, the Black and brown trans community has so much to teach every other segment of society about what it means to resist, what it means to fight for freedom over decades and generations, what it means to take hit after hit after hit and keep going. I'm so glad that, Gabriel, that you brought up D. Farmer, because the huge thing about that case was also just that it had implications for every incarcerated person. It wasn't a case limited to, the facts of being a trans incarcerated person. It really was a monumental shift in Eighth Amendment doctrine around conditions of confinement cases. And it's cited in almost every Eighth Amendment case that I've ever seen, regardless of whether the plaintiff is trans or not. And so I just think that I hope that we can not lose sight in this moment that this victory depended so much on just the grit and tenacity and brilliance of Black and brown trans women who have been doing this work against all odds, fighting within the Black and brown community, within the LGBT community, and resisting and demanding, dignity and respect.
Yeah, there's such an incredible legacy of Black trans people, especially Black trans women, fighting their own cases in so many different contexts and really laying the groundwork for our work right now. I mean, and obviously still litigating. In C. Riley Snorton's book, I just love this book so much, but he talks about, among other things, like all these legal cases that I didn't know about, where Black trans women were laying out the legal theories that we use now, almost 100 years ago in some cases. So, I mean, there's just an incredible legacy that all of us are continuing to build on. So we have a bunch more questions. I don't think we're going to get to all of them. I do see, so there's one question that I think is kind of beautiful and we should respond to it, about advice for allyship. In the workplace, I would also maybe extend it beyond, but are there things that people can do to advocate for clear HR policies with supervisors, HR offices, unions, etc.? What can people be doing who want to show up for trans people and LGBTQ people in this moment?
I mean, I'll borrow this, this from the Black Lives Matter protest. Silence is death. I think that so much of allyship is speaking out when you have to, and it's not in a moment to be reactive. It's being proactive in any instance that you can. I saw so many social media posts were saying, "Why is this an issue? I can't believe I didn't even know that you could be fired for being LGBT." You can, and there's also so many other contexts where being LGBT can subject you to adverse consequences from the law and society in general. And so it's on all of us to be aware that we live in a diverse country and not everyone has the same opportunities. Not everyone is having the same experience. And so to be a good ally means empowering yourself, educating yourself and doing what you can in your space and your privilege and your power to make sure that everyone is having the same experiences, having the same opportunities, and that everything is fair. And I think so much of that starts with a look inwards and making sure that, again, you are doing the work within yourself to empower yourself. You're not, it's no, well, I won't say that, but yeah, I'll just say that. And so in this context, like say that you are in an HR position, again, like Malita was saying, like Chase was saying, unemployment numbers within the trans community are huge. And so, getting fired only happens if you're hired. And so we have to talk about getting trans people hired. We have to talk about making sure that people have healthcare, things like that. And so again, just trying to limit the idea of what this holding meant in terms of when it can actually apply. So we have to understand that there's so much change that we need in society in terms of making the play field fair for everyone. And so that goes, if you're a manager, hire trans people, make sure that your healthcare and your policies are inclusive, make sure that everyone in your workplace knows what harassment is, and that if you do these things, there's going to be a zero tolerance policy. Because again, it's just the reality for trans folks in the world everywhere, even here in New York City, even in some of the most liberal places, it's not good. And that's just, those are the facts. And so education, standing up, using your voice, that's the biggest thing.
One thing I would add too, I think, is that, like tax systems and other systems of law that we take for granted are designed very much to sort of be racist, to keep people down. And I think that we, especially white folks in positions of power, have a responsibility to be more creative and innovative in how we redistribute resources, both in our lives generally and in the workplace. I think, if there are barriers to people accessing healthcare, then figure out ways to create funds to pay for healthcare, whether it's through the workplace or outside of it. Right now, folks who are awaiting a DACA decision are in, that is just an unbelievably tenuous position to be in. Pay for DACA renewals for your employees, pay for attorneys for employees who are facing different forms of discrimination, whether it's because of arrest and criminalization, whether it's because of immigration status, whether it's, because they have to fight for access to healthcare or bankruptcy in a hospital or any other number of things. We think a lot of times it is, there are some things that we need to do, like make sure that you have your paperwork updated so people can use their names and pronouns and get access to healthcare as a formal matter. But I think we also have to be more, sort of affirmative and creative and sort of moving resources around, even if it technically appears to sort of violate the law. I think it often doesn't. There are often workarounds that are legal that people figure out in other contexts to protect people in power. So we have to figure them out to protect people without power as well.
I think another thing, in terms of like very tangible steps that people can take to be better allies, everyone who is currently employed by an employer who provides health insurance to employees can today go and request a copy of the health insurance plan and read through it, pay special attention to the exceptions and see what exceptions exist in terms of coverage to really parse out whether the health insurance policy that your employer provides excludes coverage for gender affirming care, because so often those exceptions have existed in these health insurance plans, for years, and they really go unnoticed. And so when we talk about hiring trans people, it also means preparing them to arrive at an environment where they're not going to immediately have to fight for their own just ability to be present and work in this environment with other people. And so I think that that's one thing that you could do today is just better understand the parameters of your health insurance policy and start those conversations with management, with HR, so that when trans people, you might think, oh, I don't have any trans colleagues, but part of that reason might be that your employer has an exclusionary policy. So I think that that's one very simple, easy step. And I will say it will make a huge difference for when trans employees are actually arriving at your work environment.
I'm just going to see if I can knock out a couple of the questions quickly. So one person asked in the chat, can you bring a case about being discriminated against for being LGBTQ, even if the discrimination happened before Monday? And the answer is yes, you can. And so long as the statute of limitations hasn't passed, which varies state by state, this is what the law means, this is what the law has meant, you can bring a case. There is also a question about the implications for bisexual people and for non-binary people and gender non-conforming people. As true, the decision was like very bi erasing, kept using homosexual or gay instead of LGBTQ, and didn't speak specifically to non-binary people in any way. That said, the reasoning absolutely applies. Everything about the decision says if you are a woman who's attracted to other women and you're discriminated against, that's because of sex. That applies whether you're attracted to only other women or women and men and non-binary people or whatever else. It's all because of sex. Non-binary people, the same thing. So the decision says, if you're discriminating against somebody because they identify with a sex other than the sex they were assigned at birth, then that's discrimination because of sex. So that covers, trans men and trans women. It also covers non-binary people, even though it's not written out as clearly. And gender non-conforming people, nothing about the existing law saying that you can't discriminate against people on the basis of sex stereotypes. Nothing about that has changed or gotten any weaker. You can still bring a case saying I was discriminated against because people just perceived me as being not masculine enough or not feminine enough or whatever else. So we're getting near the end. I wanted to just also give everybody a chance to share any final thoughts.
Well, thank you for facilitating, Gabriel, and to everyone for joining. I guess I would, just one of the things that I've been thinking about that we touched on is, how many people that we've lost along the way. And one of the people who has been a mentor to me was Lorena Borjas, and she died of COVID on March 30th. And I've been thinking a lot about sort of the way that, she had a sort of mutual aid approach to work, a way of caring for people that was very much outside the law while also engaging with the law as needed. And so I think for me, one of the ways that I'm trying to hold the balance of the optimism and the joy of the decision with the grief and the rage of the realities of the conditions of people's lives is to still act outside the law and push for sort of more creative and expansive notions of how we can care for one another, even when we can't be physically in the same space, which is really challenging. But I've learned so much about doing that, and I want to carry that with me and challenge myself to not overly rely on just the law, even when we have a much better decision than we ever could have expected. So I'll leave it at that.
Yeah, thank you so much, everybody, for coming and participating, and also for everybody who attended. Thank you so much. I guess as a final thought, I just really encourage people to take time to educate themselves about the movement for Black trans lives, the movement for Black lives generally. Educate yourself about the movement to defund police. Educate yourself about the movements to decriminalize sex work, and really think critically about the ways in which the criminal law enforcement system is strategically and systematically, and has been for centuries, trying to annihilate Black people in every aspect of our society. So I want to just uplift that at this moment, because I think that this win should really be, feeding us fuel to keep going. This is not the end.
My internet connection is being kind of weird, so I don't know if you all can hear me. Yeah.
It's a little shaky.
I'll just say very briefly, I just want to say, thank you all for attending. And as I look through the panelists and the attendees, I see some familiar names, and I think that we all recognize, Gabriel, Chase, and Malita, and I, that the work that the ACLU does is built on so many different communities and people, and that we're not here if it was cases from our trans colleagues at other orgs who have been bringing these cases and who have been doing the work. We're community, and I think that's always what, you know, this case that we just won, but there are so many amazing trans people out there who are doing great work, and I just want to kudos to them and give them recognition.
Thank you. That is so true. Yeah, absolutely. It takes a whole community and a whole movement over a long period of time, right? And I also just want to thank the three of you for being here and for doing this work and for talking with me. I feel like probably all of us have had a lot of situations where we've been the only trans person in the room or the only trans person on the case, and actually having multiple amazing trans colleagues to work on this stuff with is pretty fantastic. You all are amazing, and so are the people on this call. So thanks everybody, and let's keep it going.